Well, hi, my name is Todd Nash, President of the Oregon Cattlemen's Association, here today with Sarah, and really appreciate you getting on here today, Sarah, and all the help you've been to Oregon Cattlemen's over the years, and we're very fortunate to have your expertise in a very complicated world. So, Sarah, do you want to further introduce yourself, where you're at, and what you do there?
Sure. I am a water rights attorney, which means I am in Portland, Oregon, instead of lovely Wallowa County like yourself, Todd. And I practice at Dunn Carney, which is a law firm here in Portland. Although I have focused a lot of my career on water rights, which is why I'm serving as the Water Resources Committee Chair for OCA. I also do a lot of other types of legal work, a lot of agricultural real estate transactions, public lands work, access rights, a lot of the time focused with water. And our firm does basically everything except for family law and criminal law.
Okay. All right. Well, for the purpose of today, I wanted to drill in, for lack of a better analogy or acronym or whatnot, none of those above, but
Good water pun.
yeah, water pun. There we go. So, but we want to talk about in-stream water rights, and that's come up recently in Lake County. I know that in the southwest corner of our state, it's been a topic of conversation. And so, first of all, what is a in-stream water right?
So an in-stream water right is a water right that is not taken out of the water source. So historically, water rights in the West required diversion of the water right or of the water source in order to create a water right. So you had to either take the water out of the stream or the lake or the groundwater and put it to a beneficial use. So you had to have diversion. Now, the courts a long time ago decided that certain types of water uses didn't require actual diversion, like livestock use. For example, livestock will drink directly from the source, and so you don't need to take it away from the source first to establish a water right. But other types of in-stream uses weren't recognized until much later. So in the 1980s in Oregon, the state legislature recognized certain uses of water that remain in stream as beneficial uses of water. Those uses being pollution abatement, fish and wildlife uses, and recreation. And so those types of uses don't need to be diverted. And the legislature also created ways in which those types of water rights can be established. So in the 1950s, there was an act to establish perennial in-stream flows, so to set levels at which they wanted certain surface water rights to have flows for the benefit of fish and wildlife, but those weren't water rights yet. And so one of the things the 1980s Act did was give a process to convert those perennial in-stream flows to actual water rights that have a priority date and can be enforced and called for. Another thing that the In-Stream Water Rights Act did in the 80s was allow certain state agencies to apply for and hold in-stream water rights. So those agencies are the Oregon Department of Fish and Wildlife, the Department of Environmental Quality, and the Parks and Recreation Department. And so those entities can actually apply for new in-stream water rights. And then the In-Stream Water Rights Act also put in place a system for in-stream leasing. So rather than having a water right that's only for in-stream use, you can temporarily park your water right in stream, so to speak, or there are split stream leases where for part of the season you can lease the water right in stream, and the leases are held by the state agencies as well.
Okay, well, that's a pretty deep dive into that, and so you've been involved here recently with what's going on in Lake County and ODF&W having some sort of a public meeting on identifying, I think there was maybe 13, 14 different streams down there that they intend to apply for in-stream water rights. And what advice can you give that community in what they're doing there? And I know you've worked there before, and maybe you could talk a little bit about that.
Yeah, well, I guess just starting kind of with a background of water rights in that area, the current applications, which I'll talk about in just a second, are not the first in-stream water rights in Lake County. As I mentioned, in the late 80s, this In-Stream Water Right Act went into place, and there have been applications made primarily by the Oregon Department of Fish and Wildlife all around the state, and there were applications in the 90s for some in-stream water rights as well. But since the state adopted an integrated water resources strategy, one of the strategies in there is to apply for these in-stream water rights. And so once that went into place, the Oregon Department of Fish and Wildlife made more of a concerted effort, going kind of basin by basin around the state and filing a lot of these applications. So you had mentioned the southwest portion of the state. We just saw the Oregon Department of Fish and Wildlife file a bunch of applications in the Umpqua and Rogue River basins. But now what we're seeing and what we anticipate soon are applications, as you mentioned, in Lake County. And so rather than, a few applications that were filed in the past, this is a bigger effort, more stream reaches included in these applications that we anticipate will be filed soon. I have just attended Oregon Department of Fish and Wildlife public meeting. They've had a few either in person or remotely over the past couple of weeks, and kind of laid out their plan and the applications they expect to file here either the end of August or beginning of September. And so we do expect to see those soon, as we've seen in other river basins over the last few years. And so advice to give folks in Lake County, I guess number one, be mindful of what's going on, get information about whether the Oregon Department of Fish and Wildlife plans to file an application on a water source that is utilized by your operation. Try to figure out, if it will impact what you are already doing or plan to do for your property. And there are certain ways that you can challenge these applications if they do get filed as well.
Okay, and one of the things that surprised me in visiting with you earlier was the fact that they could file for in-stream water rights for water that currently didn't exist. And so if there's some efficiencies in irrigation or by some other method, there is more water there into the future, they can actually lay claim to that. And that was a little bit surprising. I'll let you talk about that a little bit. I also want you to talk about the complexities once this takes place with the change of points of diversion, maybe groundwater drilling, and some of the impacts that it has surrounding all of this.
Sure. So when the Oregon Department of Fish and Wildlife applies for in-stream water rights, they are not limited by the amount of water that's actually available in stream. So if you and I were to apply for a water right today, you know, the Oregon Department or the Oregon Water Resources Department would look at water availability, and they would look at what they call the 80% exceedance rate for normal appropriations where you take water out of the stream and use it, 50% exceedance rate to take water out of the stream and store it. And so there's different rates that they look at, but they always look at whether water is available. And those exceedance rates are based on when water is available. So an 80% exceedance rate, the water would be available at least 80% of the time. Now, when the Oregon Department of Fish and Wildlife applies for in-stream rights, that doesn't matter. And so the Department of Fish and Wildlife decides how much water they think is needed for the particular use they're applying for, and how much water is actually available analysis doesn't happen. And so you can often end up with in-stream water rights that exceed the water that's actually available in the source. And so the effects of that are several, as you mentioned. If an in-stream water right is put in place, it basically ties up all the remaining available water in that source, as well as upstream from the reach that the Oregon Department of Fish and Wildlife's permit would include. And not only that, but sometimes water rights are canceled, and those water rights, the amount of water, the volume, the flow goes kind of back into the public sphere. It's not always available for new appropriation, because if a water source is already fully subscribed, then, you know, the department still won't let new appropriation. But if there was availability, it would kind of be subsumed by the in-stream water right, which exceeds anything that's actually available anyway. So it kind of ties up the ability to apply for new water rights thereafter. Additionally, groundwater in the state of Oregon is managed conjunctively with surface water. So when we're talking about tying up the water resources, we're not just talking about new surface water, which is kind of easy to envision. You know, you've got a certain amount of surface water, and the in-stream right comes above all of that oftentimes, and, you know, no more surface water available. But when someone applies for a new groundwater right, if it's within a mile of a surface water source, the Water Resources Department also models whether that new groundwater use might have a potential for substantial interference with a surface water source. And one of the ways they determine if there is a potential for substantial interference is based on these in-stream water rights. And so if you're applying for a rate that's more than 1% of an in-stream water right, the Water Resources Department says there's a potential for substantial interference, and we therefore deny your new groundwater application. And so it has an effect on groundwater too. And then you had also asked about the impacts on existing water rights. And so once in-stream water rights go into place, they have the priority date based on either the perennial stream flows for ones that were converted, or, as we're seeing with these newer applications, based on the date of the application to the Water Resources Department. So the priority date is pretty junior. And so if you already have existing rights, your priority date will be senior. But once an in-stream water right goes into place, you can't change your existing water right in any way that might injure the in-stream water right. And so moving a point of diversion upstream, for example, is considered an injury to the in-stream water right, because you're taking the water, you're diverting the water out of its source, higher up than otherwise. And so you're depriving that stretch of the water that would otherwise be there. And so if you're trying to make that type of move or other modifications that the state might determine would injure the in-stream water right, you'd then be required as part of that transfer to mitigate for that injury. And that mitigation typically means taking some of your water right and converting it to in-stream use to make up for the injury. And so these in-stream water rights can impact existing rights as well.
Yeah, pretty worrisome. And I know the guys that have dealt with this, it seemed far away, you know, on the far catty corner of the state that I live in, but it's really been troublesome for them working through this process. And I know Craig Herman has been real vocal on it, and I really appreciate his good work on it. Now coming to Lake County, and really happy that you're engaged in this. Is there something that we should be looking at as far as a legislative fix, or something that keeps this from being as onerous as it is right now?
Well, a legislative fix, I mean, you know, the rules can always be changed by the legislature because they were developed by the legislature. I think what I am most concerned about when I see these large groups of in-stream water rights getting filed, applications being filed, is I worry about future water management. You know, obviously I worry about the impacts right now to existing water right holders, but beyond that, I also worry about how the state is balancing future needs if we're tying up all the water resources for fish and wildlife purposes, which is an important use. But also, you know, we're dealing with severe drought throughout the state, seeing how our preparations for drought are non-existent. You know, how are we going to deal with that going forward? How are we going to fight wildfires when there's no storage to dip into to fight the wildfires that have just become more increased and more severe lately? And so, you know, what I would really like to see is within the system that we have, the state doing a better job at not only moving forward with one piece of its water resources strategy, that is tying up the water with these in-stream water rights, but also balancing the other pieces that are so important. We're not doing anything to increase our water resiliency, drought planning, storage, you know, ability to provide water for food and forage, you know, going forward to support our state and others that rely on the products that we create in this state. And so, you know, we could look at whether there's different policies that could be put in place in the legislature to address in-stream water rights in general, or with, you know, outside of the legislature, just doing a better job at managing our water resources, and instead of focusing just on we're going to put everything in in-stream flows.
Yeah, well, I really appreciate that. We have a lot of challenges here with water, and really, you know, it is our lifeblood for everything agriculture, but everything life. It just revolves around water. Sarah, really appreciate your time here. We're going to wrap this up. Do you have any closing thoughts on how people might better arm themselves when this comes to their town or their county?
Well, you know, there has been discussion about working with the agencies about what is important within the basin. There are always a lot of voluntary stream restoration efforts and water conservation efforts ongoing. And so, you know, there's a concern that these types of applications really hamper everyone's ability to work through those types of voluntary agreements. And so perhaps ahead of time, really focusing on those and the impacts it have that are greater than what could be done with these junior in-stream water rights. But also, if these type of applications get filed in your area, understanding the procedures, that you will have a deadline to protest if you believe the application shouldn't be approved, making sure you're aware of those deadlines, because once you miss them, you can't then challenge the applications and try to work on alternative solutions. So just being mindful about the procedure and the deadlines involved, and don't miss those.
Yeah. And I'm going to throw a little something out there. If there was ever a reason to join Oregon Cattlemen's Association and have somebody that helped you through a process, this is reason enough right here. So, Sarah, I can't tell you how much we appreciate you, your expertise. Seen you testify in Salem a number of times. You're so well respected down there, and I know you have an aversion to being over complimented, but there's not a person that's ever dealt with you that doesn't appreciate how hard you work and how well you do your job. So
well,
thank you so much.
Thank you, Todd. The feeling is mutual.
All right. Have a good day.
Thanks. Bye.